going for the motion. The speaker number one will be speaking for 7 minutes, and their speaker number two will be speaking for 7 minutes. They have saved 6 minutes with the rebuttals. After that, ND2, ND number eight, ND2 are going for against the motion. The speaker number one will be speaking for 8 minutes, and the speaker number two will be speaking for 7. They have saved 5 minutes for rebuttal. Now, as the round will begin, I, as a moderator, will be going backstage with one of the members of ND2 and will inform you about the time in the chat box. If the judges allow us to begin, I would request the tech support team to send me and the other member of ND2 to backstage.
Yes. I think the team for the motion can start.
All right. Good evening. Am I audible to the judges?
Yes.
All right. With the permission of the judges, the speaker one of Team ND1 would like to begin his arguments.
Yes.
All right. A very good evening, judges and the moderator and to my opponents. So we, the Team ND1, would be speaking for the motion that the contempt of court does impose a restraint on the freedom of speech. So firstly, talking about what exactly is restraint, everyone pretty aware of what freedom of speech is. Restraint, according to the Oxford Dictionary, may be defined as a measure or a condition that keeps someone or something under control. So the idea of thinking twice before talk is already enshrined in the Article 19 of the Indian Constitution, which confers the freedom of speech to each and every one of us. So nextly, coming to the Indian justice system, as we all know the nature of the Indian justice system, it is a system which relies heavily, by and large, on precedents due to being derived from the common law system. And it being so heavily dependent on previously decided cases. Now the cases may be really old. It may be 50 years old, it may be 60, 70, maybe even a century old, but it still holds a value in the court of law due to the Indian judicial system following the common law system. And there is bound to bring it is bound to bring up discrepancies in judgments, and any erroneous judgments. As we all know, there is always a possibility of human error. And if any such human error exists, it tends to be carried forward, and to raise a voice against the same, and to also provide constructive criticism. The citizens might want to raise a voice and provide constructive criticism to the courts on what they feel is right and what they feel is wrong. And as we all know, society is something that changes its value systems, its attitudes, its as time goes on. But it can be seen that the people who would have
Speaker, why is there a need of the citizens to criticize any judicial pronouncement of the court? To my understanding, litigation is majorly between two parties, whether it's private parties or one private and the other being the government. Unless and until it is a public interest litigation, I don't think that there should be a need to criticize the judicial pronouncements or to express any public opinion with respect to same.
Thank you for the question, Judge. Team ND1 would like to submit that even judgments, with all due respect, even the honorable judges are humans at the end of the day, and they merely interpret the law and pronounce a judgment, which also involves some of the discrete and their opinion, which may or may not be agreed upon by the population. And as we all know how diverse the population are. And Team ND1 would like to bring into consideration that we have people of varying castes, various races, various religions, various practices, various social classes, and each and every single person of this such a diverse population cannot be expected to view a particular thing in the same manner, and even with the same laws.
You cannot understand what I asked you. When a particular judgment. Understand, when a particular judgment is not affecting another person who is expressing his opinion. Like I said, a litigation is between two parties. Whether they may
Okay,
be
okay.
two private parties, one may be a private and the other may be government, right? So when a person who is not a party to the list is how is a judicial pronouncement which is not concerned with a particular person, why should he be allowed to express any form of opinion with respect to such judicial pronouncement?
Team, anyone would like to submit that it is these judgments, as I just mentioned in judicial system, that form the law of the land, and these judgments can tomorrow be cited as a precedent for a case in which I might be involved. Firstly. And secondly, since it is the legal and the justice system which affects our entire nation as a whole, Team ND1 believes that every citizen would have some cause for concern, and hence they would feel the need to voice out their opinion. With the judge's permission, may the speaker one of Team ND1 continue with the arguments?
Yes.
Thank you. Nextly, talking about Article 19(1), sub-article 1 of the Constitution, as we all know, it confers to every citizen the freedom of speech and expression. And again, it is paramount. It is of paramount importance to understand the importance of the speech in our country. There have been observations from various cases, both Indian as well as American. There's been Samuel Roth versus United States of America, Arthur Terminalu versus City of Chicago, and so on, and several other cases where it was held. Freedom of speech and expression will always prevail except where contempt is manifest and mischievous. So Team ND1 would like to bring to the attention that the freedom of expression in itself already possesses a restraint that one can't slander and misuse this freedom of speech and expression. And would like to add to that, saying that the contempt of court merely adds to it and imposes a restraint on what was already restrained.
Speaking, you were citing two case laws. Can you please repeat the citations?
Some of the cases I mentioned are Terminalo versus City of Chicago, and Charlotte.
Decided by which court, if I may ask?
This was the American Supreme Court.
American Supreme Court.
Yeah.
And what were they exactly interpreting while deciding this case?
I'm sorry.
So let me put it another way. Let me simplify it for you. Does any right in the form of Article 19 exist in the American legal system?
Team ND1 would like to submit that yes, even the American system has a system of rights that is conferred to the people, which includes the right to speech and expression. Apologies, as the speaker one cannot.
Speaker, what is that instrument called? What is that instrument called? Which bears
it's called the Declaration of Human Rights.
The Declaration of Human Rights.
Yes.
Do you understand that there is a difference between an act, a declaration, a covenant?
Yes, I do, Judge.
Between all these instruments, a declaration cannot confer anyone a right. It's mainly declaring that there might be some rights. It's upon a court.
And UNHCR is not exclusively for America.
Sorry, ma'am?
But United Nations Declaration of Human Rights you're talking about.
Yes, but these, yeah.
Human rights. What I heard was UDHR, and it is not solely applicable to America.
Yes, ma'am. Team ND1 apologizes for lacking specific. But I would like to point out that these are some of the declarations and some of the documents which certainly have the effect of conferring the right. Apologies for the lack of specific information, judges.
Kindly restrict yourself to Contempt of Courts Act.
Sorry?
Kindly
beg your pardon?
restrict yourself to Contempt of Courts Act. Every nation has its own system of imposing and implementing contempt law. So it would be better if you could elaborate us on the Contempt of Courts Act with respect to whatever you are submitting.
Okay, noted, Judge. Would the judge require the speaker of Team ND1 to bring it up immediately or later
No, no,
in?
you can bring it whenever you want.
Yeah. Thank you, Judge. The speaker of Team ND1 was about to bring it in his subsequent arguments.
Yes.
So, with the judge's permission, can the speaker of Team ND1 continue with his arguments?
Yes.
Thank you. So, nextly, talking about current affairs in the Indian system, it is seen that people are not free to say whatever they want. Because earlier this month, as we all know, a comedian named Kunal Kamra had tweeted certain things on the Indian Supreme Court because of having this opinion that some of the judgments of the Supreme Court of India were in his opinion, were politically colored and were in the favor of one particular party. Though the team ND1 doesn't justify this, team ND1 would certainly like to point out that again, he didn't have complete freedom to express what he wanted or to include whatever he wanted in his speech. And this was again seen in the way in which a lot of the people, a lot of the lawyers filed petitions against him. Even the Justice K.K. Venugopal.
Can you please state the motion which you are holding right now? Are you stating that contempt of court? Are you in support of the position that if a person expresses an opinion against the judicial pronouncement, it is contempt of court or it is not contempt of court?
Team ND1 would like to submit that the point we are currently examining is not whether it's contempt of court or not contempt of court, but merely the fact that even the idea that the slightest, even the anything which causes the impression that it may be deemed to be contempt of court does have a restraining effect.
Probably I was not clear. I would like to rephrase. Whether you are for the motion or you are against the motion. Please clarify your stand.
Team ND1 is
with respect to Kunal Kamra's tweets. What is the motion? Are you for the motion or against the motion?
Team ND1 is for the motion that the contempt of court has a restraining effect on the freedom of speech.
Restraining effect. And you did concede that Kunal Kamra's tweets were inappropriate.
Team ND1 merely submitted that though the question of whether it was appropriate or not was another point of discussion. The main contention, the main point Team ND1 was trying to make here was that he was absolutely unfettered in his right to express whatever he wanted. He was facing this restraint, and even if there is no real restraint, this whole furor that happened on social media would definitely be sufficient to cause this fear and this alarm in the minds of people and cause them to refrain from them.
You have to take a position. Since you did bring up this topic of Kunal Kamra's tweets, you have to take a clear stand that whether you agree with him or you don't agree with him. It should be as clear as that. There cannot be a middle way. That no, what he said was incorrect, but there should be a right to express personal opinions against judicial pronouncements on public forum. You have to.
Apologies.
That's why I asked whether you're for the motion or you're against the motion.
Apologies, judges, but Team ND1 was trying to make the point that there has been a restraint of freedom of speech without taking any political stance. Apologies, team.
No need to apologize. Please continue.
Okay, thank you. So, nextly, talking about the contempt of court, it may be genuinely understood that people are genuinely scared when the ability to determine what is fair criticism under the contempt of court through fear. And coming to the Contempt of Court Act, Section 5 of the Act states that fair criticism is not to be termed as contempt of court. However, the team ND1 would like to point out that again, what may be deemed fair criticism and what may not be deemed fair criticism is something which is again determined by the judiciary itself when the remark has been made against the judiciary. and the judiciary is the one that gets the power to decide whether the same was constructive in nature or not. So, Team ND1 would submit that this again does tend to have a restraining effect, as by and large, generally, as we tend to err on the side of the cautious, it does have a restraining effect. Nextly, the Contempt of Court Act
Peter,
also talk.
you said that since it's the judiciary only which decides upon the aspect as to what would constitute its contempt, do you suggest any alternative as to who can decide as to when one conduct or one act would constitute contempt of court? Do you have any suggestions you can put forward to us?
Team ND1 would like to say that as long as there is human judgment involved, as long as there are people involved, there will always be it will always be colored by what they feel with their sense of right and wrong, their value systems, their attitudes, and their political leanings as well. So Team ND1 finds itself in a difficult position to say who exactly would be in a position to determine this. So Team ND1 can only say that it can be determined by a reasonable man, and again, this is again a pretty vague concept, and Team
Who will
ND1.
determine, who will determine as to which person is a reasonable man? Will it be
Reasonable man.
that the person himself will be assuming that I am reasonable and hence I will be deciding?
Yes, Judge. This is exactly what Team ND1 was trying to tell. That this is a pretty vague concept, and again, as per no time and again, the term reasonable man has been used in various other statutes, but again, there is no clear definition of the same. So this is a blurry area or a sort of gray area to fall under.
No,
The point.
this is not a vague concept, Speaker. I think you should choose your words very wisely because what would constitute reasonableness has been elaborated in n number of judgments in for with respect to each and every
Yes, Judge.
statute which finds the reference of this term reasonable. As far as the Contempt of Courts Act is concerned, there is no reference to such reasonableness criteria which you are referring to. So I'm not able to understand as to what system you would like to establish whereby the Supreme Court or the High Courts, who are deciding thousands of cases every day, if a person, a pedestrian who's walking on the road who has no concern with the case, he opens his social media account and posts something ABCD against in a derogatory manner, of course, against that judicial pronouncement. And what you're putting forward is that conduct of such a person shouldn't be scrutinized by the court. It should be scrutinized by some vague person altogether who doesn't exist probably at this time.
Clarification, Judge. Team.
Why I'm saying this, Speaker? Why I'm saying this? You need to be very clear with what you are saying, what line of argument you are using here. On one hand, you are saying that it is a different subject matter that Kunal Kamra's tweet shouldn't be considered. All right, they leave that topic altogether. But when such a situation exists where every Tom, Dick, and Harry is now putting something or the other on a social media account against prestigious institutions, then don't you think that there needs to be some form of a check against such persons?
Yes, Judge. Team ND1 would like to clarify that there is the code is having such a system of a check, and this is exactly what imposes. I'm sorry, moderator, my voice is echoing. Okay, yeah. So the Team ND1 was telling that there exists such a system which puts a check on on what can be said and what cannot be told. And as Team ND1 has already mentioned, the judiciary in history, since history has always been such a prestigious authoritative body, and this is exactly the reason the Team ND1 would again like to clarify that it's arguing on the stance that the contempt of court does in fact impose a restraint on the freedom of speech and expression.
All right, please continue.
Thank you, Judge. Nextly, speaking about the freedom of speech and expression. And as we all know, there has also been devised a three-test method to determine what may be deemed as ambiguous, and what may not be deemed as ambiguous when it comes to the restriction on freedom of expression to be justified. So, according to the European Commission of Human Rights, in the Sunday Times versus the United Kingdom, there was established a three-step rule, a three-test rule. Firstly, the test one spoke about the test provided by law. So this test stated that the government must follow a written law that is clear and not ambiguous. Otherwise, people wouldn't know when and how they might be accused of doing something wrong. Again, Team ND1 would like to clarify that there is a certain written law that is clear and that is to be unambiguous, and this again has a restraining effect on the freedom of speech and expression. And test two talks about for the respect of the rights, or for the reputation of others, to protect national security of public morals is the only legitimate ground for restricting speech. So it is supposed to be complete list and not just, for example, a list that states can add to. So any restriction must pass this legitimacy test. So Team ND1 would like to again clarify that there is a very restricted view according to the second test, which understood, moderator, which mentions the grounds for the legitimate grounds for restricting speech. So this logically follows that anything which goes beyond this ambit would obviously not be considered as a legitimate ground, and again the action would be taken against the person for expressing himself. And the final test would be if it is necessary in nature, because freedom of expression is a right that must be upheld as much as possible, and restrictions should be applied only when really necessary, and punishments must be proportionate. Again, what is necessary and what is not is again something which is decided by the system in itself, and this again, as I already mentioned, has a restraining effect on the freedom of speech and expression. Sorry, moderator. Now over to speaker 2 of ND1.
Judges, we would like to interrupt a bit. Speaker number 1 took 25 seconds more than the time he is asked for. Would we be including, with the permission of judges, would we be including this in the extra time which they have taken, or the judges are allowed
You
to
can
take?
deduct it from mine.
I think it's fine.
Well, fine. 25 seconds.
As the discussion of judges will not be counting it as an extra time. You can now, as the judges may allow, speaker number 2 for ND1 can speak.
With the judge's permission and the moderator's permission, I'd like to begin the arguments by the second speaker of ND1.
Yes.
It has been submitted by by the first speaker of ND1 that the topic for the day is a restraint on the freedom of speech by contempt of court. In essence, what we're talking about is that the existence of contempt of court and the principle that it applies and the spirit that it applies, in a sense creates an air of restraint on the freedom of speech when it is exercised by members of the society. As you mentioned earlier, that members of society often find certain judgments to be opinionate on certain judgments because they understand that in a future case that this might be a case law that might support or go against their own thing, and essentially they find a part of themselves in the judgment and often give criticism for the same. Now, I would like to read out to you Section 5 of the Contempt of Court Act of 1971. Contempt of Court Act of 1971 essentially lays down Section 5, which is fair criticism of a judicial act is not contempt. Subject to the provisions contained in Section 7, a person shall not be found guilty of contempt of court for publishing a fair and accurate report of judicial proceedings or on any stage thereof. It is understood that there is a provision for fair criticism of the judicial act, and does not hold the person under that act to be contempt. However, this is not seen in real circumstances. After the amendment of 2006, where the aspect of public interest and truth were introduced, it was not really seen. The biggest example for this would be the Prashant Bhushan case, which happened quite recently. a little background on the Prashant Bhushan case. Prashant Bhushan, who's an eminent lawyer in India, made a couple of remarks, made a few remarks in 2009 to a certain magazine on the nature of chief justices and how the chief justices of the era have been for India. Proceeding with, continuing from that, he had made a several amount of tweets on the of the judicial system and the Supreme Court in India. He essentially did this out of public interest, and he did this in all fair, and that is also what he had stated in court. However, it is to note, and here I'll be quoting from the judgment itself. The court opens in paragraph 71 of the judgment, where the court states, "We do not want to go into the truthfulness or otherwise of the first part of the tweets mentioned, inasmuch we do not want to convert this entire proceeding into a platform for political debate." It essentially shows that the court has outright denied the truthfulness that has been claimed by the opponent. Even so, that the court has not in fair trial considered the truthful nature of such a tweet and the statements that were made.
What are you trying to say?
Thank you for the question. Just the team speaker 2 of ND1 would like to submit that despite there being provisions for freedom of speech, there is always a way. There is a way in which the court gets away, despite having provisions to help the person who's been held under contempt of court. In this case, Mr. Prashant Bhushan, and this effectively, despite having provisions, puts a restrictive nature to the freedom of speech in India, because a person who will want to express public opinion, when thinking of a case like Prashant Bhushan, who had the truthfulness test denied in paragraph 71, will obviously have a restraining nature in his freedom of speech, and that essentially happens to be the point that ND1 speaker 2 is trying to bring about using this case. With the judge's permission,
but Speaker, wasn't your co-speaker criticizing this aspect that in matters of contempt of court, it's the court itself which is adjudicating upon such matters, and hence it's basically a situation where a person is a judge in his own cause. Then why are you quoting the judgment of the Supreme Court with respect to your motion? When your speaker bears this view that the court shouldn't be adjudicating upon the issues of contempt of court, because there might be some conflict of interest involved.
The speaker 2 of ND1 would like to present that following and continuing the speaker of ND1's argument, we are essentially trying to establish that despite there being provisions in the Contempt of Courts Act and in the Indian legal substance, there is still a nature of arbitrariness that has been exercised, and this essentially plays into this essentially forms as another chain that holds in freedom of speech in terms of public opinion. With the judge's permission, I'd like to continue my argument.
Yes.
There's a question, like there's a concern which I want to ask you. So I'm I'm saying that there's a concern which is like troubling me. You participants must have done elaborate research over your contents. So one thing which bothers me, that why the other speaker and even you are very much confined to the case of Kunal Kamra and Prashant Bhushan. I know they are very recent cases, but can you please elaborate and throw light about the cases which you have studied more, and the other cases which deals with the contempt? Leave these two cases. There are many instances. There are a lot of book. If you type contempt of court on internet, Google, you'll get a lot of things. But I just want some cases which you have researched as a law student, which are not in news and live law these days. So can you please, what you have researched, can you just focus over that other than Prashant Bhushan?
The speaker of ND1 has received the question, and we'd like to talk about Section 13 of the Contempt of Court Act. Section 13 of the Contempt of Court Act reads, Content of Court Act reads, notwithstanding anything contained in any law for the time being in force, no court shall impose a sentence under this act for a contempt of court unless it is satisfied that the contempt is in the nature that it substantially interferes or tends to substantially interfere with due course of justice. And the second subsection B basically says that the court may permit in any proceedings for contempt of court justification by truth as a valid defense if it is satisfied that it is in the nature of public interest and requests the invoking of such a defense in such cases. That is the reason why we brought in the case of Mr. Prashant Bhushan. But we would also like to bring in the case of Shreya Singhal versus the Union of India, where the court essentially, where it was held that Section 13 it was understood that Section 13 also suffers from a vagueness, as it lowers the threshold of reasonable restriction by constructive hindrances to the administrative and justice proceedings. There must be an actual obstruction, or in the words of the court, or as in the words of the act, a significant obstruction which needs to be maintained. Now, what is significant and what is actual obstruction has not been clearly defined, and this is what was exactly shown from the Shreya Singhal versus the Union of India case, that Section 13 suffers from a characteristic of vagueness, and that essentially does not.
I ask the question.
Yeah.
Who decides if any provision in any act, in any statute, if it is vague, if it is arbitrary, who decides that?
Who, as in when it's brought into the court of law, Judge?
Okay, so ultimately we reach the same place?
No, Judge, what we're trying to establish over here is that the Contempt of Court Act, despite having provisions for freedom of speech, still has a certain nature that lets the courts use certain powers and in turn act as restraining chains for freedom of speech. We're not talking about annihilation of freedom of speech. We're not talking about completely doing away with it. We're just talking about a restraining nature, something that blocks someone or controls someone or puts into their mind a certain fear or a certain hold back option against expressing something, and in our case is the freedom of speech. And the point that we've been trying to make as
the court has been granted this power under what provision? The High Court and the Supreme Court. I have another question. Do the lower courts also have power to draw contempt?
It's only this, to my knowledge, judges, it's only the Supreme Court and the High Court.
So from where do they derive their power?
There are provisions under the Constitution. I believe for the Supreme Court, it's Article 125. 125, if I'm not wrong. I'm
129.
129. I plead ignorance, your judge, but there is provisions in the Constitution which allow the Contempt of Court Act to in turn play in the court of law. And what we're essentially seeing is that the court of law, and in cases that have seen the use of contempt of court and the explanation of contempt of court, have been used by the court in certain circumstances, which have in turn given an innate nature to the freedom of speech, and have restrained it in certain areas and in certain degrees that it clarifies as restrainment, but not total restrainment, or not in anything that is to do away with it. So essentially, the freedom is there, but there is a feeling of restraint that is experienced, and that is what we're trying to. That's what we've been trying to put. That is what we've been not trying. That is what we've been putting through our arguments, that the restraining nature exists despite having codifications, despite having acts which have certain articles and sections which allow people to express the freedom of speech. And the reason for such reason for such restrictions, as I understand, is often it should not hinder the administration of justice. It should not be defamatory in nature. It's for public security, helping foreign relations, and these are various reasons as to why this has come in. But these reasons have had an expanded scope, and that in turn brings about a restraining nature to the freedom of speech. however little, there still exists a restraint, and that happens to be the argument and the side of ND1, which is we speak for the fact that contempt of court does restrain the freedom of speech. With your permission, I'd like to continue with my argument.
Sure, sure.
Thank you, Judge. As my speaker, as the moderator, I'd like to request how much time do I have left?
Don't waste it. You just have enough. You can.
Okay. I'm sorry, judges. I'd like to continue with my argument. As the first speaker clearly held that in the European Court of Human Rights case, the Sunday Times versus the United Kingdom, where the Sunday Times had essentially released a certain publication which spoke against a certain decision, and that essentially came to the court of law. They provided 3 tests. Now, in response to the question made by judge number 1 to speaker number 1, where the judge asked for a system, we would like to say that the judiciary system is well equipped to deal with such matters. However, the choice of enacting and the choice of doing these tests at the end of the day depends on whether the court makes the decision to take these tests. The tests are available. As provided, the test number 1 is provided by law, that there must be something that's provided by law in order. Test number 2, which talks about the right and reputation of other people. And test number 3 is that freedom of expression must be given the utmost importance. So the tests exist in foreign and in India in India. It just comes down to the point of whether the court is willing to use this or not use this. And clearly seeing in the Prashant Bhushan case, in the 100-page judgment that was released, that the defense of truth, which is under section 5, section 13, and fair use under section 5, were clearly ignored by the court, and have doing so have used terms. And here the speaker number 2 would like to quote that in the 108-page long judgment, the court held terms such as the Committee of Nations and an iron hand of ruling. This, however, has not shown any legal reasoning as to why Mr. Prashant Bhushan was held. There was no legal reasoning. Even so, with the question of why only 1 rupee was fined, is it an indicator that there must be a fear? There must be a fear when it comes to contempt litigation? Because rupees 1 is a fairly little amount, and for a case of such nature, it is understood that there must be something more. It does not make sense to charge a person who has, under the eyes of the court, derailed the court from judgment and has defamed the court, and has made the people lose faith in the court, that there must be a substantial amount of fine and punishment levied on the person. But however, why was only rupees 1 fine? This clearly shows that the court
Speaker, for that, you have to go through the entire judgment as to why was rupees 1 levied as a fine for that particular case. I think you should go and read the entire judgment as to why was so little an amount levied upon Mr. Prashant Bhushan.
Yes, sir. Yes, Judge. Sorry.
For your assistance, I would like to state that in that particular matter, a message was required to be given. And that message was that even a person of a stature of Mr. Prashant Bhushan can be held guilty of contempt. And even a person of that stature who has spent his entire life in the court corridors and arguing before courts, even he cannot take that liberty of saying anything which he wants at a public forum. That was the message that was required to be given.
Yes,
right? That was why that sort of a judgment was passed.
Yes, Judge.
It was not concerned with what amount is required to be levied. That amount is provided in the statute.
Yes, Judge. Judge, here having heard the judge, ND1 speaker 2 would like to present that isn't it also true that for a man who has walked the halls of the courts of law, delivered hundreds of judgments in favor in the right interest of justice, doesn't he also deserve such an eminent legal person? Doesn't he also deserve the idea of having a perfect having a fair trial where sections which have truth as a factor, which has public interest as a factor, which has fair use as a factor, be deemed as tests and not blatantly ignored, which happened in Prashant Bhushan's case. If it is clearly understood
You are saying that a trial is required to be given. Which court is going to conduct trial? Sessions court, civil judges court, magistrates court. Which court is going to conduct trial? Or Delhi High Court? Which court conducts trial with respect to contempt of court cases?
No, judge, when I mean trial, I'm sorry for the words I've used. I mean the tests that we mentioned, and also the defenses that are provided under the Contempt of Court Act. I'm sorry for using the word trial, and I humbly apologize for such a mistake that I've made.
All right.
What the speaker of ND1 would like to point out is that for such an eminent jurist personality to be caught, not to be who has roamed the halls of justice, he also deserves the full extent of what the Contempt of Court Act can provide him, and that essentially was not recognized under the court, that this would turn the debate, this would turn the entire proceeding into a political debate. The speaker too of ND1 would like to end by saying that freedom of speech has not been infringed upon, freedom of speech has not been done away with, freedom of speech has not suffered a huge blow. All we're trying to say is that, all ND1 is trying to say is that the contempt of court, through its existence, displays and deploys a certain restraining nature in the minds of people who are essentially willing to express their freedom of speech, and has also seen it throughout history and also in recent cases. And that is the reason why we, the team of ND1, believe that the contempt of court, in a sense, has a restraining nature when it comes to freedom of speech, and just a restraining nature and nothing more. ND1 speaker 2 would like to end the arguments and wishes the best to ND2 and for all the arguments. Moderator, I'm complete. Thank you.
Thank you, speaker number 2. As 30 seconds were left in ND1's speech, that 30 seconds will be added to the rebuttal time, if the judges allow. Thank you, judges. As now ND1 has finished his speech, now I would like the judges to allow ND2 speaker 1 to speak, and I would request my tech support team to send me and one member of ND2 backstage. One member of ND1 backstage, I'm sorry.
Hello, am I audible? Can you hear me and see me clearly?
Yes.
So with the permission of the moderator and the judges, I'd like to begin.
Yes.
Greetings everyone present and listening. I am from Team ND2s and I'm the speaker 1. I shall be speaking against the motion that contempt of court puts restraint on freedom of speech. The first thing that I'd like to do in my speech is clarify what the meaning of this motion is and interpret it in the spirit of debate. I believe it is a ridiculous motion to say that if contempt of court creates any kind of restraint, then side proposition wins. That's clearly not what the intention of the motion setter is. The burden on either side of the debate is to prove whether such a restraint is justified or not, whether it's a reasonable restriction, and whether the country would be better off without the law on contempt of court. Because even putting people in prison is restraining their right to free movement. Taxing people unequally according to progressive taxation is treating people unequally. That doesn't mean that these are unreasonable restraints. The question is whether such a restraint should be present or not. And it is in that spirit that we shall be making our arguments and satisfying our burden. What is the first point? Let's understand what is meant by contempt of court, especially in the Indian context. There are two kinds of contempt of court. One is civil contempt of court, which is a willful disobedience of a court's judgment or an undertaking given to a court, but that's not got a lot to do with freedom of speech. It is criminal contempt of court that we are concerned with, and that relates to making scandalous remarks against the judiciary or a particular judge, a remark that lowers the authority of the court, it hinders or obstructs the functioning of the court, the administrative or the judicial functioning of the court. So an example of this could be perhaps making baseless allegations of corruption or abusing judges or using foul language against the judges or mocking them on Twitter or making caricatures or jokes or making defamatory, inflammatory claims about them, which are
So I
unsubstantiated.
need to ask a question. If a person gives a wrong statement on affidavit before the court, then how this would whether this would fall under the category of contempt of court or not, and under what category would you term it as contempt? Because you have specified only two options that a court has.
Uh, Madam Judge, it will amount to contempt of court if that false statement amounts to, again, lowering the authority of the judge, or if it's a scandalous statement. If it fits
Only
into the
then,
definition, sorry, ma'am.
only then it would be contempt of court. Whether it will not fall under the category of interfering with the delivery of justice or
Ma'am,
functioning.
Ma'am, while I'm not aware of the specific law on that point, it might also amount to interfering with the functioning of the court. The point is that as long as it is falling within the definition of criminal contempt, it will amount to contempt of court, and under Article 129 for the Supreme Court and 215 for the High Courts, the courts have a power to punish under the Constitution. But there are certain defenses available for remarks made which might be colored as contempt of court. For example,
But if a
first it
person
is
is writing anything on affidavit, it will generally be to obtain a favorable order. It will not be scandalous to any judge or making any statement against any judge. So my question was, if there's something which is wrongly stated as per facts, whether that will also be contempt.
Ma'am, if it has got nothing to do with the court, then perhaps it would not be content. Perhaps it would be perjury if you're lying to court, especially if you're under oath. You're under an obligation to make only true statements. Therefore, it might be perjury and it might be covered under different laws. But if it has got nothing to do with the judiciary or a judge, then it will not amount to contempt of court. Uh, but what are the defenses that are given under the Contempt of Court Act? A fair criticism of the merits of a judgment. So when Speaker 2 of ND1 criticizes the Prashant Bhushan judgment for not having judicial reasoning, that's not contempt of court. That's a fair criticism, and that's allowed under the Contempt of Court Act. Truth is also a defense for contempt of court. So if you make an allegation, let's say you make a criminal allegation which turns out to be true, then that is also a defense for contempt of court. Therefore, we understand that the judiciary cannot be allowed to function without any accountability, without any checks and balances. There must be fair criticism of their judgments if these judgments are misguided, if they are wrong in law. But such criticisms must be fair, must be based on merits, and must be based on truth. False statements, defamatory claims, and things which scandalize the court are the things that are covered under contempt of court. And we believe that those are reasonable restraints imposed on freedom of speech. And we'll tell you why that is the case. Let's understand why we need a law on contempt of court in the first place. We must understand what is the role that the judiciary and courts and judges play in society. The role they play is an incredibly difficult role. They're supposed to uphold the rule of law in society. They're supposed to keep the powerful in check so as to prevent abuse of minorities and the weak. They're supposed to protect laws, legal institutions, and without courts, there will be lawlessness. The democratic rights on which our constitution, our country are built on will not be protected if there are no courts. Because these decisions have impact, real life tangible impacts on the parties, the court might be sending someone to jail, might be sentencing someone to death, might be making a judgment in a civil case which might have repercussions of crores and crores of rupees. Obviously, the side that loses might have some incentive to criticize the court or go against the court. But you need the judiciary to operate free from any kind of external fear or influence so as to be able to render a fair and free judgment. This is the exact same reason that impeachment procedure for judges in our constitution is made extremely difficult, because to have separation of powers, because the judiciary is going to act as a check on the legislature and executive also, is supposed to operate in a free manner. Therefore, this law on contempt of court exists so as to prevent the people who have certain grudges against the judiciary to act in a malified manner against the judiciary. This is why this law is important. But let's consider what will happen when there is no law on contempt of court. This will inherently give a free rein to everyone to spread any kind of lie, any kind of defamatory, scandalous statements about the courts and judges. It's going to make it harder for judges to do their jobs. It's going to make it harder for them to render free decisions. It's going to make them harder to administrate the functioning of the court. Society will lose respect for the authority of the court. So people, when their rights are violated, will not look towards the court to get their remedies, but might resort to some other illegal or unfair means of of remedying the violation of their rights, which is something you do not want in a democracy, especially when you have an impartial institution as the court, specifically instituted to serve as like a third party intermediary to protect your rights. Crime can become rampant because people might be disincentivized from approaching the court if the image that they have of the court in their heads is one of corruption, is one of biasness or unfairness. This is the exact kind of situation which laws on contempt of court are trying to prevent. But this will not happen if you say that no contempt of court is a restraint on freedom of speech and therefore we should do away with the law altogether. Separation of powers is also going to suffer because the
So
legislature is
I
going to
just want to
make law.
stop you. I just want to stop you for a moment over here. Uh, One thing that concerns me is that you have very much magnificently described what is criminal contempt over here, what is scandalous remarks and everything. That is a criminal contempt. But you are not very much clear about the civil contempt. Let me say it very clearly. If we are having working on a writ jurisdiction of 226, supposedly in high courts, so if a mandamus is issued for a direction, what action of the respondents will come in the ambit of civil contempt and what actions will come in the ambit of criminal contempt? If you are not clear with the question, I can repeat myself.
No, sir, I think I understand your question. So, civil contempt happens when there is willful disobedience of a court's judgment. So, when a writ of mandamus is issued that you must perform your function in the right manner, if that public authority refuses to perform its function in the right manner under the directions of the court, that will amount to civil contempt. However, if something else is done, for example, a remark is made which scandalizes the court, or there is some sort of disruption in the proceedings of the court, that will amount to criminal contempt. Since this debate is about freedom of speech, and freedom of speech relates to scandalous remarks or remarks which lower the authority of the court, it is criminal contempt that we seek to focus on. I hope I have answered your question with satisfaction.
Yes, you have done it.
Thank you, sir. Right. So, in a society in which the authority and institution of courts are not respected, the rights which these courts are supposed to protect cannot be protected in the best possible manner. What this does is it creates a, a problematic situation for the weak, vulnerable, and minority sections of the society. Because the powerful still have access to resources which they can use, abuse, and manipulate to get their own interests sorted. The rich people can employ their money, hire muscles, hire security guards, and sort of manipulate or bully the weaker people. Because the weaker people do not have access to a judiciary which they now conceive to be unfair, which they conceive to be incapable of protecting their rights, they don't really have any third party to resort to. They have no choice but to bow down and succumb to the injustices that they are being subjected to. Therefore, you
Speaker,
need the.
Speaker,
Yeah.
I would like to just take your view with respect to the situation that is existing and vis-a-vis the motion which you are holding before us. So we are talking about the contempt of court law uh, in comparison with the freedom of speech and expression that exists, as to whether it curtails it or not. Uh, we think that recently the courts have become a little too sensitive about any form of criticism that is being made against them. Um, Earlier, there used to be cases when, during the course of arguments, a lawyer might go to the extent of reacting, and then the courts used to hold him for contempt of court for usage of any particular foul words or any unparliamentary conduct. But nowadays, courts are taking cognizance of conduct which involves putting tweets on a particular Twitter handle or probably a Facebook post. So, don't you think that time has now come when some form of there's a situation where one feels that this contempt of courts act is being used more excessively by the courts to basically satisfy their own sensitive attitude, as if I might put it. So there needs to be some form of a check, probably in the form of an amendment, or probably in the form of certain guidelines which the court might itself lay down. Uh, don't you think that this should be followed, or this should be existing in the particular circumstances that are existing as of today?
Sir, I couldn't agree with you more. I realize that times have changed, and increasingly the courts have become more sensitive, and they've started overly using, even abusing the Contempts of Court Act to limit any kind of criticism that has been made against the judiciary. However, I believe the appropriate reaction against that is not to remove any provision on contempt of court altogether. I think you were right to point out that the law needs to be amended. Like any policy or any law, when times changes, when social attitudes change, and when the reaction of judges to certain laws change, you need to keep tweaking these laws. You need to keep them up to date so as to prevent their misuse and abuse. And while that is my position, I believe that when balancing the interests of having contempt of court and maybe the judiciary misusing it a little bit versus not having it at all and giving people the free rein to say anything that they want about the judiciary, I would much rather accept the few cons which will come with an imperfect law of contempt of court than have no contempt of court act at all. That being said, I don't think I'm not sure if uh, tweets specifically being used as being cited as contempt of court is something wrong in and of itself. It depends on what is the content and substance of that tweet. So, in the Prashant Bhushan example, it is my personal belief that a contempt of court was perhaps not warranted, and maybe the law needs to change to reflect that. However, tweets in general cannot be put outside the purview of contempt of court because tweets in social media generally have a wide appeal. So, if someone who is a celebrity, who has a wide public appeal, makes a statement about the court, let's say a scandalous statement, then a lot of people will hear that, will consume that information, and that information will influence the reputation of the court. In that case, even tweets, even social media posts, newspaper articles, everything needs to be covered as statements of contempt of court. However, there needs to be amendment in the law so as to restrict the scope of its application.
All right.
From time, I'm not, I think I have about a minute remaining. I'll just conclude my points now. Uh, from times immemorial, the institution of the court has been colored and characterized by a sense of decorum, a sense of formality, a sense of respect and dignity. It is because of the same reason that lawyers are supposed to be in a particular kind of uniform when they are present in court. They're supposed to address the judge as Your Excellency, Your Honor, or My Lord. These are the things which are supposed to protect the institution of judiciary from becoming a laughing stock. Because if such formalities are not observed, if the Contempt of Court Act is not present, again, the functioning of the judiciary will be inhibited. An example of this is what happened in a previous case. I can't recall the name of the case, but certain advocates, they had taken to the courts, they had stood on the benches and chairs to protest against the judiciary's functioning. This inherently resulted in the administrative functioning of the court being inhibited. This again amounted to contempt of court according to the court itself. And we believe that this was a right interpretation or a right judgment because you cannot allow lawyers or anyone to obstruct the carrying out of justice by these courts, because it's not only their rights that you're talking about, it's the right of every citizen of this country, and because of that this institution must be protected. For all of these reasons, we are very, very proud to oppose. Thank you.
Good afternoon, everyone. This is speaker
Just
two of.
number two, just a second. I would like to interrupt. I extremely apologize for that. Just sincere request to you that when you are answering the questions put up by judges, once you have finished your answer, can you please just ask the judges or just inform me that now you have begin with your arguments? That will be easier for me to stop and start time. Thank you, sir. Thank you. Tech team, please send me backstage and from the.
May I begin now?
Yes, you may begin. Don't waste the time. You begin.
Good evening, everybody. I'm speaker 2 of Team ND2, and I'll be speaking against the motion that contempt of courts puts restraint on freedom of speech. The freedom of expression guaranteed under the Constitution and the independence of the judiciary are two basic and most important constituents of a democracy. Constructive criticism is the most important ingredient for the development of democracy, and the Supreme Court should protect free speech. But where to draw the line? When the criticism has the tendency of lowering the authority of the judge and even obstruct the administration of justice, the court has the power to punish any such act which tends to demean the value of judiciary under the Contempt of Courts Act 1971. Why do we need this provision of protecting the courts? Why do we need this? So, firstly, I would like to say that it upholds our constitution. The powers of contempt of Supreme Court and High Court are independent of the Act 1971, that is drawn from the Constitution directly. So, to delete the provision relating to criminal contempt, particularly scandalizing of courts, will have no impact on the power of the superior courts to punish for contempt in view of the inherent constitutional powers, as these powers are independent of statutory provisions. Secondly, it ensures safeguard for judiciary. The judiciary is the guardian of rule of law in India, and it needs to be made sure that it is protected with all kinds of problems that do or might hamper the fluent administration of justice. The provision of powers to punish for contempt is significant for ensuring such respect of the judiciary. Such kind of power is necessary to prevent interference with the course of justice and the authority of the court. Thirdly, protecting public faith in judiciary. Amendment in the definition of contempt may reduce the overall impact of law and lessen the respect that people have for courts and their authority and functioning. Also, by abolishing the offense in India would leave a legislative gap. Also, what about the impact that it would? Yeah, sorry.
Speaker, do you think that the current framework of the Contempt of Courts Act somehow one would say violates the traditional principle of nemo judex in causa sua? Are you aware of this Latin term?
Yeah,
Nemo judex.
nobody should be a judge in its own cause.
Yes, yes. So doesn't this current legal framework, which exists with respect to the Indian the Contempt of Courts Act, violate this principle that has been existing for I think more than a century?
Yeah, as a would-be lawyer, I have extreme faith in the judiciary, and regarding this, I think that if the judiciary will not decide, then who will be the judge of this decision, that if it is hampering the sanctity of our legal system, the sanctity of our court and our judges or not? So it's not like the person against whom.
In case of Supreme Court, the President of India can decide. In case of the High Courts, probably the Governor or the Chief Justice of India can decide as to whether contempt of court has been committed or not. Some other I wouldn't say delegation, some transfer of powers can definitely be made with respect to upholding the image of independence of judiciary, because we think that if you are only adjudicating as to what would constitute your contempt, then somehow it is not being independent, it is being impartial, it is being biased. What do you have to say about that?
Sir, I'm really grateful to you that you shared this knowledge with me. And now that I think about it, you are in some way right. So I won't be able to answer you back because you are definitely correct. So I can simply agree with you on this point. And I would say that's a very good suggestion.
All right, continue.
Yeah. So continuing with my speech, um, I would like to address the fourth issue, that is the impact that it will have on subordinate courts. The Constitution allows superior courts to punish for their contempt. The Contempt of Court Act additionally allows the High Court to punish for contempt of subordinate courts. Thus, if the definition of contempt is removed, subordinate courts will have will suffer, as there will be no remedy to address cases of their contempt. Lastly, I would like to wrap it up by saying that fair criticism is not contempt. The 1971 Act contains adequate safeguards to exclude instances which may not amount to criminal contempt as defined under Section 2C of the Act 1971. It means that not all cases of contempt are considered.
Madam Speaker, is there any provision in the Act itself for not punishing innocent publication?
It is up to the court to decide that if it falls under the category of contempt of court or not. So, as Sir gave the suggestion that there should be an independent body to decide if it is contempt of court or not, then
At this stage, sir's suggestion cannot be the answer of every question. I'm asking if innocent publication has not been made
yes, ma'am.
punishable under
Yes,
the
ma'am.
Act
The Act itself says that constructive criticism does not amount to contempt of court.
You were saying that fair criticism does not amount to contempt of court. I'm asking if there's innocent publication, will that amount to contempt
Like,
of court
ma'am,
or
where
not?
you see the intention of the person behind publishing a certain comment.
I'm asking about any provision in the Act itself. Is fair criticism allowed under the Act?
As
Is innocent publication
yes,
allowed
ma'am.
under the Act?
Speaker, what does Section 3 state? What does
Where is
Section
it
3 state? Let me simplify it for you. What does Section 3 state?
Sir, I don't know. I have not studied the.
All right.
All right, Speaker, continue.
To conclude, I would like to say that whoever the person may be, however high he or she is, no one is above the law, notwithstanding how powerful or how rich he or she may be. This is the basic principle of the concept of rule of law, which asserts supremacy of law and puts everybody on equal footing. It is the basic principle of governance of any liberal and democratic society. The judiciary, which is the central pillar of democracy in India, is the guardian of the rule of law. It holds a crucial position in the order and the maintenance of democracy. Thank you.
So you have very well concluded your speech. There's one thing which I want to ask from you. That's a very simple question. Fair criticism. If a judge is criticized, or if a court is criticized, it will not consider, because they are humans. They will not consider it as a fair criticism. They might get a contempt charges issued first. So, is there any provision that you can have any other authority to raise the concern that you have been charged wrongly? Like, I will give you a hint. I'm just talking that, do we have an appellate jurisdiction in case of contempt Fair criticism, if I criticize a judge, he will, according to him, I am not criticizing him fairly. He will draw contempt. Now, is there any other person, any other authority, appellate authority, who can tell that whether I or the court is correct? Throw some light over the appellate jurisdiction. That is basically a crux of the question.
Appellate jurisdiction is basically giving the person the power to appeal in a court of higher jurisdiction.
Do
So,
we have it in contempt?
yes, sir. I think.
So you can tell us that we do not know details. Okay, fine. So any other senators want to ask something? Just call into moderator.
I think I'm done. All right. Thank you.
I would like to point out one thing here, that speaker number 2 only spoke for 5 minutes. And I'll be adding that, and now we'll be starting with the rebuttals. So I would request my team. First of all, I would like to ask anyone, speaker 1, who will be speaking in the rebuttals. It's you or your host.
Team ND1 would like to submit that the rebuttals for Team ND1 would be carried out by Speaker 2.
Speaker 2. As Speaker 2 will be conducting the rebuttals, I want my tech team to, the members have done it already, tech team send me back on stage, and as the judges will allow, the time for rebuttals will begin.
With the judge's permission and the moderator's permission, Speaker 2 or ND1 would like to present their rebuttals for the ND2's arguments. The first question that we would like to bring up is that the opposition has not taken the scope of contempt of court to change the concept of contempt of court scope to extremes, has not taken it in what all actually falls under the scope. There essentially is a narrow scope that has been observed in their entire speech, and they've seldom spoken about how the contempt of court, in essence, does not restrain freedom, but have spoken about how the doing away with of contempt of court would severely hinder society, and about how how the ideal justice system looks like, and the guardian angel of India. Point number 2. Speaker number 1 clearly spoke about how there are provisions that help freedom of speech. Then my only question is, why wasn't it used in Mr. Prashant Bhushan's case? And that is the simple. That's the question 2 that I would like to ask the opposition. Question number 3: the opposition has not made any argument on how the system that currently exists, in essence, this prevents misuse or prevents the existence of a resistant nature to freedom of speech. They have not spoken about how the courts protect this fundamental right. They have not spoken about how, when a person approaches the court, when a person is dragged to the court for contempt of court, they have not spoken about how they are protected, and how this is not how contempt of court is not taken advantage of. The fourth question we would like to pose is that the very essence of contempt of court lays in the idea of fear. If at all we are speaking about an idealistic justice system, then the question of why is there a need to use fear in order to restrain? Judge number 3 is not present. Moderator, I'd like to note that judge number 3 is not present. Is the moderator here?
He must be backstage.
I believe he can hear us, ma'am.
Yes, yes.
He's texting me on the chat room. Judge 3 is also present.
I can see him now. I'm sorry for I apologize for the intrusion, judges. I'd like to continue with my questioning. The question number 5 that the members of the 4 parties asked is that in most if they're mentioned that the law has in itself has a perfect notion, then we must understand that the law and the interpretation of law is how law will be seen in society, and how law will be seen by the people who approach it. And if the court, the most apex court in our case, which is the Supreme Court of India, is not looking at the tests, is not looking at the defenses that was not observed in Mr. Prashant Bhushan's case, then isn't that essentially saying, or isn't that essentially giving the notion that despite freedoms existing, despite provisions existing, there is a certain restraining nature, because despite it existing, the court does not call upon that codification of court, does not allow the invocation of that provision, and hence leaves the person defenseless in that particular aspect. And the last and final point that I would like to ask the opposing team is that why was there a mention of doing away? Why was the scope of the entire argument that they made in terms of what if it wasn't there, what if it was there? The topic itself, and I quote, contempt of court puts the restraint on freedom of speech. So in essence, as I understand it, or as it should be understood, is that the opposition inherently should try to prove the safeguards, inherently should try to give us case laws in where the safeguards have been implemented and how people have been protected with the defenses given under Contempt of Court Act, which was seldom seen in the argument. And these will conclude the questions to the opposition, that is ND2 in this matter.
So ND1 had 6 minutes 30 seconds for rebuttal. They've only used 3.36 seconds. Rest will go ahead if ND2 asks them any question for the time to answering. Now, as I would like speaker number 1 of ND1 to tell me who will be rebutting so that the other member and me can go backstage.
From ND2, you mean?
Yeah, yes. Stop.
Yes. Speaker 1, I shall be rebutting.
You'll be answering. So when the judges allow the rebuttal time of ND2 will begin.
Okay.
Yes.
If I understood all the questions correctly, there are 6 points of rebuttal that I have. First, you have alleged that we have described the scope of contempt of court too narrowly. We reject that contention. I believe I have described the scope of contempt of court and the scope of the law as the law is, quoting from the Contempt of Court Act as well as like judgments. If they have any follow-ups on that, if they can explain why the scope is too narrow and why it is not what the law actually is, then perhaps you can respond to that better. Second, they've talked about the Prashant Bhushan case, and they use that example to claim that, oh, there is so much abuse of contempt of court. Well, on the Prashant Bhushan case, firstly, the defenses of fair criticism and let's say the second defense of truth, even though they were not considered by the court, it's a reasonable interpretation to not consider those defenses in that case. Why is that true? Fair criticism, as described in the Contempt of Court Act, is not fair criticism of the judiciary as such. It's fair criticism of a judgment on its merits. The tweet that Prashant Bhushan had shared was about corruption of judiciary and like breakdown of democracy and CJIs in the judiciary having a key role to play in that. The defenses of truth cannot apply here because you can't prove or disprove the truth of that statement. And this is not fair criticism of any judgment that the court had delivered. So in any case, in that case, these defenses were immaterial. So if the court ignored those defenses, I believe it was still a fair judgment on their part. But proceeding on that idea, and this leads to the third point that they talked about, and this is my third point of rebuttal, it boils down to how can you prevent any misuse of contempt of court. We have to give the power to decide whether there is any contempt of court or not to these courts and to the judiciary, because there is simply no other body or individual who is best suited to make that determination. Why is this the case? You can't give this power to the president or the governor, because the president and the governor are bound by the constitution to obey what the Council of Ministers asks them to obey. Therefore, you will be giving too much power to the executive and to the legislature to decide whether there has been contempt of court or not, thereby creating a disbalance in the separation of powers that exists in society. You can't ask some other body also to do this, because there is no other body which is like the court, which is democratically elected. The court has to do this, and we have entrusted a lot of these things to the court in the past. Even if there is a personal matter for the court, there might be some other judges deliberating on that point, but it's still the judiciary sort of acting as a judge in its own cause, and we're okay with that. Even appointment of judges is done by a committee which is full of judges. So even there, you have a judge acting in their own cause. This is a price which we as a people have collectively decided that we are willing to pay because there's simply no other alternative. At least when you give this power to the judiciary, there is some kind of check and balance because judges, they are trained, they are educated in colleges in their experience to at least put aside biases, to at least put aside their own prejudices while deliberating on a point of law. So a judge again who is involved in a contempt of court case is likely to say that I will not deliberate on this point because I am involved and defer it to some other judge. You can't expect this in any other institution. Therefore, the judiciary is best placed to make determinations of whether there has been contempt of court or not. Fifth, on the point of the court is not looking at defenses. I've already covered this in the Prashant Bhushan example. And sixth is, again, they are trying to squirrel by trying to give you a one-sided interpretation of what the motion means. As law students and as lawyers, they should aim to have a reasonable, a harmonious construction of what the motion means. When the motion says that contempt of court puts restraint on freedom of speech, we agree that there is going to be some restraint. But that's not what the debate or the spirit of this motion is about. The motion is about whether such a restraint is justified or not, and whether this restraint should exist. Therefore, our argument as to why this restraint should exist, why the country and society would be better off by letting the Contempt of Court Act to exist, are the relevant arguments, and they have not engaged with any of those arguments. If we were to accept their interpretation of the motion, then there will simply be no way of arguing from opposition side, because there's always going to be some restraint, and there would be no point to having this debate at all. Therefore, we must understand what must have been the motivation behind setting this motion and then continue the debate. Of course, this is up to the judge's determination, what they think is a fair interpretation of the motion, and I'm going to leave it up to them to decide. I do see that I have some time remaining, so I'm going to ask three questions to speaker. I'm going to ask it from team ND1, and they can decide whichever speaker wants to answer this. First, they've said that overruled judgments are law in common law countries because precedence is law. Can they point me to at least one judgment in which an overruled case was used as a basis for law? Because the entire point, to my understanding at least, the entire point of overruling a judgment is to make that point of law obsolete and replace it with a new point of law. That's the first question. Second, they've said that judges can make mistakes and therefore you shouldn't have contempt of court, which seems to be an inherent contradiction. In fact, judges are fallible, they do make mistakes, which is why you can fairly criticize the merits of a judgment that they have made. So the Contempt of Court Act as it exists sort of covers that situation. And my third question is it absolute freedom that you want? Do you think that all freedoms that the Constitution guarantees, especially freedom of speech and expression, should be absolute? Like, take the example of sedition or hate speech. Do you think the law that puts restraint on those things should not exist because it is restraining free speech? Those are my three questions. Thank you for your time.
I'd like to request ND2 speaker one to just re-mention the second point. I seem to have lost. I'm sorry. Please.
Sure. Sure. So your speaker one said that judges are prone to making mistakes. They are humans. Humans can make mistakes. My argument against that is that contempt of court as it exists right now allows you to fairly criticize a judgment that a court has made. So what is the problem with having contempt of court when you can sort of take care of the situation of a judge making a mistake by fairly criticizing the merits of that judgment?
Okay, so just a second, speaker number 2 of ND1. I would just like to point out here that their ND2 had 7 minutes and they've used 6.31 seconds. 6 minutes and 31 seconds. They still have they still have 29 seconds left. Now, when you start answering, your time will be started. You have already used 33 minutes and 36 seconds of yours. So, as the judges allow us, you will speak. I'll start your time.
With judge's request and permission, I would like to rebut my fellow opposition.
Yeah.
The first point, the first question the opposition has raised is the question of overruled. We'd like to make a correction that my teammate or rather my co-speaker, mentioned ruled and not overruled. If that was lost due to some communicational error or in some notion, then we totally understand and we apologize for it. But we have written statements where we have used the word ruled and not overruled. And I request, if there's been any mistake from our side, then we are sorry. But then it was meant to be ruled. Question number 2: judges make mistakes. I think it's fairly understood that judges are humans at the end of the day, and they hold their own biases, and they hold their own they have their own understanding of matters A, B, and C. And what we're essentially trying to say is not the fact that a judge who's elevated to that position is not competent of that place, is not competent of that office. What all we're trying to say is that there are certain times when this bias can, not will, but can seep in to judgments, and that makes it liable for public. That makes it open to public opinion. The question number three that the rightful speaker of ND2 presented was the quest of absolute freedom and absolute freedom of speech. We would like to state as ND1 that we have never been against the Contempt of Court Act. We have never been against. We have never stated that there is a complete infringement of freedom of speech. We are saying that the Contempt of Court Act is a necessary legislation. However, certain parts of this codified act are not used the way they ought to be used, and that essentially the point that this creates an element of restraint in people, or in public personalities, or in general the normal man, every Tom, Dick, and Harry, to express freedom of expression, because there is a certain restraint that despite having the protection because of the codification of law, I might still end up losing out, or I might still be held under contempt of court. And that in essence creates the element of fear, which is a valid restraint on the freedom of speech. We're not saying that there is an infringement. We're not saying that it is completely done away with. We're essentially saying that there is a restraint caused by the Contempt of Court Act. And we have not essentially said that the Contempt of Court Act should be done away with. With 30 seconds left, I'd just like to point out one more thing. When we mentioned the first question to ND2 speaker 1, we essentially spoke about the scope of debate and the scope of the argument that they're presented. Now, it is understood under harmonious construction, as the speaker has rightfully pointed out, but the literal meaning still takes precedence over harmonious construction, and the literal understanding of the topic is with regard to the contempt of court having a restraint on freedom of speech. And with that, I'd like to end my response.
Speaker number 1 of ND2 still have 29 seconds left if they want to use it, if they want to say anything.
Yes. I'll just make one quick point. If we were to go by this literal interpretation of the motion that they're talking about, I'd like to ask them, can they point out one argument that the opposition will be able to make if the motion was to be interpreted in a literal manner? If they can do that, then I'll be very happy to hear them.
Do I have the permission to refute that? I mean, I know I don't have the time, but
you don't have the time left now.
Okay, we understand.
According to rules, you're not allowed to. And as of now, the time for rebuttals for ND2 has also ended. So now that marks the end. If judges would like to add up to conclude anything.
Yeah.
That marks the end of the finals. Both teams have exhausted their time. The judges would like to add up anything there in the liberty.
Speaker 1 of the ND1 team, he got really nervous while Judge 1 was asking him questions. You need to be more confident while, especially when you are in a virtual debate competition. And as regards the second team, ND2, I don't know if Speaker 2 was aware, but she was yawning on the screen. Maybe she thought that she's not visible to us, but it's that time of the day when we are also sleepy, but we choose not to yawn. And Speaker 1, I was asking you a question relating to false statement on affidavit, Actually, that was based on a personal experience where the High Court had drawn criminal contempt because a false statement was made on affidavit, and the criminal contempt was drawn on the basis that it interferes with the administration of justice. That's it. If any other judge wants to add, I think judge number 3 is not with us. He has disconnected.
Oh.
I am right. Am I not audible or something?
You're not
I'm not
visible.
visible. I'm visible. I'm here. Like it's showing that you are in the show. Everyone can see.
If you want to add anything to the team, they
No, I don't want to add.
the
I very much
final round.
appreciate the feedback which you have given to them. It's just that ND2 speaker 2, you have to be more professional on stage when you perform. You were good. You were good, but uh, tell us something. Let it be wrong when you are asked, but don't just quit out that I do not know a thing. I will just agree with the judge. And ND1 speaker 2, I would like to say that you were taking questions very efficiently by the fellow speakers, but when the judges were asking you thing, judge number 1 especially, then you kind of panicked, which is like in a debate competition, national debate, in the final round, anything can happen. Anyone can ask anything. What I think, you should just calm down yourself, and your mind works very fast. You should just comprehend the question and answer them. Don't panic in such situations when we're standing in the final round. That's it. I want to conclude myself by saying that.
Um, uh, First of all, congratulations to both the teams for reaching the finals. And it was a wonderful and commendable effort on both the teams. All the speakers were very good. A little bit of details have already been discussed by the other judges. To my understanding, this is a very different kind of a debate competition where the judges are also allowed to ask questions. Usually in debate competitions,
I haven't been
it's
witnessing
the
such kind of
debaters
things.
who deal among themselves. But still, it was a very nice, a very an effort worth an appreciation, where all the speakers were ready to entertain questions, and they answer. They made their best efforts to answer each and every one of them. I think that's it. It's been a long day, so all the best for the upcoming results, and good luck.
Thank you so much, all the judges. The results will be declared pretty soon. The link will be sent to you for the validity session on YouTube. We will stream live on YouTube. I would like to thank all the participants and the judges, and we would like to
Thank
apologize if we have
you.
done any.
Thank you so much, moderator. Thank you so much.
Thank you
It was
everyone.
great being here.
Thank you, sir.
All the best teams.
All the best.